Today, we are very excited to continue our back to work conversations. This week, we're focusing on the legal side of things, which I know we're all very excited to learn about. Today, we have two special guests. We have Joleen Hughes and Kirsten Daniels. They're here and ready to answer our burning questions. The format we're going to do is kind of similar to what we did last time. I have some initial questions I'm going to ask them, and then we can open it up to the group for more questions. But yeah, to get started, I would just love for Joleen and Kirsten to introduce yourselves, a little bit about what you do. Joleen, we can start with you.
Sure. Hi, everyone. I'm Joleen Hughes, and I own a law firm called Hughes Media Law Group. I'm a music commissioner, and I'm also on the board of SIF. So I'm very heavily involved in the arts. And my day-to-day life, however, is really advising clients across all genres of business, from media technology to consumer products. And so what we do is we provide very general but overall guidance to our clients, not only from corporate and corporate formation and financing, but all the way through employment and operating your business on a day-to-day basis. So as part of that, obviously, a lot of our clients have been going through everything from the payment, the PPP loans, all the way through, like, how do we open correctly? How do we get back to work? How do we continue to work? And that's what we work on generally. I am really happy that Kirsten has agreed to join us, because Kirsten and I actually have worked together on a couple of projects for clients when they get into trouble. So Kirsten is my employment related expert who helps us when we are going down any sort of path with clients that are that look like there may be problems or situations that might cause employers or employees to feel a little bit stressed about where they are in the world. So hopefully that's a good segue to introduce Kirsten.
It is. Thanks, Joleen. I am apparently having internet connectivity problems today. Perfect day for that to happen. So I apologize. Some of you are freezing on your screen, which is the indication to me that there's an issue on my end. But in any event, so if I pop off and have to pop back on, I'm really sorry. So hi, everybody. I'm really glad to be here. Kirsten Daniels. I work for a law firm in Seattle called Cairncross and Hempelman. I'm the lead employment attorney at that firm. As Joleen sort of suggested, I help businesses with almost everything having to do with their employees. I think the only two things I don't touch on are, like hardcore workers' comp defense, because no one in Washington state does that, thanks to our state-run system. And I don't do immigration, but otherwise I primarily spend my days hopefully helping businesses stay out of having significant issues with their employees or going sideways with employment law. But when that does happen, often because they haven't called me first or didn't listen to what I tell them, I do help do employment litigation as well. So like Joleen, I've been helping businesses since March 15th navigate the COVID-19 crisis, and initially laying off workers, and now hopefully returning people back to work more permanently than not. So we'll see. But
great. Thank you, ladies, so much for being here. We're so excited to pick your brains. I guess the first question is more of a general, good diving into things, because you obviously both have experience with dealing with COVID and businesses and employees very recently. So how has the pandemic in general impacted the employer-employee relationship? And are there new guidelines we're seeing being recommended around different COVID protections for both the employer and the employee?
I'm happy to start. I think that initially it was, how are we going to keep everybody employed, and how do we choose who is not employed, and how, at the very beginning when the loans were not coming through, it was very difficult for people to figure out if they could even, pay the bills. I know for probably the biggest problems that I've seen are, when you let employees go, how do you let them go in a way that, is respectful, but also definitive, because I know that sounds really harsh, but unfortunately, if you are an employer, and I know some of you guys are employers, there can be, it's never a comfortable conversation. So when I give this sort of advice, I'm always mindful that most employers do not want to let their employees go. Most employers do not want to deal with, these sorts of challenges, and it's not comfortable. And especially small businesses, and especially arts community, it's even more uncomfortable. But, you can do things wrong as an employer, and then you are then even in worse trouble, because now employees might have ability to come after you for different ways that you've handled it. So in my line of guidance, it's really trying to balance all of that to make sure everybody who's affected, has a path forward. So.
Yeah, to dovetail on that, I've seen a lot of that, and that's been a really big part of what I've been helping businesses with as well. Another significant area is just navigating all the different types of leave that's available. There's the Family First Coronavirus Response Act and the leave that comes along with that law. That was particularly confusing at the start of this when, employees were being laid off, but does that count as leave? And then we had this stay-at-home order, but sort of not really. And that law remains in effect through the end of the year, at least. We'll see if it gets extended past December 1. And if, for example, leave allowances are reset. But when you've got that leave, an employer's, employer provided PTO. There's the mandatory sick and safe leave in Washington State. Then we have our Washington State paid family medical leave. And how do all of those things overlap and interplay with each other has been a really huge issue. I think another one, and I believe one of the specific questions will touch on this, so just to preview, is what happens when you're back up in business, you're up and running by and large, but there is an employee who does not want to return to work for whatever reason. And that has been a lot of what I've been working with clients on, is just, and the famous lawyer saying is, what are we supposed to do? And the answer is, it depends. I mean, I have general advice, that's probably applicable across the board, but it really depends from work site to work site what the best answer is. But those are sort of the big issues. And then I think another one, probably less applicable to this group, is just how have these months of working from home for a lot of businesses changed the corporate culture? Sort of going to your question about employer-employee relationships. In the past, businesses relied a lot on it's our culture to have everybody in the workplace. That culture has clearly shifted, and good, bad, or indifferent, it has. And how will that impact the relationships going forward is a really interesting question.
Actually, I wanted to bring up two more things too, and I know we're lawyers, we're talking a lot, but one, the two things that one is very specific, and because we have a good group and good swatch of people here, it's the difference in sort of how we've bent the rules a little bit on employees versus contractors on who's getting compensated. And so that issue creates some ripple effects. So when one department decides that somebody is an employee versus an independent contractor, and the business has, say, classified them as one or the other, if you're going from independent contractor and now suddenly you're an employee and you're eligible for unemployment benefits and things like that, that has direct impact not only on the business, but it ripples all the way through to federal law on taxes and how you have to pay taxes. So if you're saying, okay, yes, as independent contractors, you get to claim unemployment. I'm now starting to see some of our businesses getting letters from other state departments saying, oh, well, we see that you're an employee. Well, you weren't an employee, you were an independent contractor. If you now have to go and refile your taxes, you now get hit with penalties for failure to pay, failure to file correctly. So I think that a lot of times some of the departments within state and cities don't maybe understand that interplay. The other one is the mental health issue surrounding all of this. So I know that there's a lot of resources and our state is really good at that, but I think that there are employees that have struggled with the change, and there are employees that have maybe are not, don't have significant others to quarantine with. And so I've dealt with that with several clients who have different employees who have different abilities to cope with what's been going on. And how do you support them? But yet, if you're still employing them, how do you expect that they're, contributing, since maybe the resources for paying people are not quite what they were?
Great, thank you so much. So moving on to, our industry just got the green light to go back to work. So we're excited, but we want to make sure we're doing it very safely and legally and properly. And so one of the biggest questions that we keep hearing is the legality of liability waivers. And is it legal for employers to have their workers sign a liability waiver, but also other types of documents, whether it just be an acknowledgement of reading the company's COVID safety protocols? Like, what's going to be the new normal for that whole realm?
Yeah, and I'll start with this one since this falls squarely within what I've been doing. And I'll preface this by saying reasonable minds can differ on this point. Hold on, I have to corral my dog here. This is another joy of working from home. Sorry, everybody. But reasonable minds can differ on this point, but I think the general consensus among me and my direct colleagues is an employee waiver is not going to be worth the paper it's written on. I strongly feel that they will not be enforced if you require to have employees sign waivers stating that they're, waiving any claims against the company having to do with possible COVID-19 exposure at the workplace. As a general rule, employees cannot waive rights prospectively regarding their employment, and certainly not rights having to do with the right to show up to a workplace that is safe. There's clearly been no case law on this yet, no cases that we have seen, because there just hasn't been time. But I suspect if employees were to challenge these type of waivers, they'd win. And the reason why is they create what in the law is called a moral hazard. So if employees sign away their rights to, bring any suit against the employer based on exposure to COVID-19 at work, that gives the employer an incentive to loosen their safety requirements at work because, hey, the employees can't sue us, they've signed these waivers. And, certainly an employee could bust through the waiver in that instance in any event to probably claim gross negligence or something to make the waiver not worth it. But it's my opinion that they would just be seen as coercive, creating a moral hazard, and wouldn't be worth, again, they just wouldn't be enforceable. So I say don't go through the pain and suffering of having your employees sign one and getting off on the wrong foot with them. I think your efforts are better spent implementing your safety protocols, and certainly have employees sign an acknowledgement like, hey, I understand these are the safety protocols put in place at work. I acknowledge that I've read and received them. I acknowledge that I'm going to follow them, because if you have employees sign something like that and then they don't follow the protocols, you have that document to go back and rely on in performance managing that employee. But, and so, some people are referring to those as waivers. I am not. That's an acknowledgement of policy, just like you would have an employee acknowledge a handbook policy, for example. So certainly do that.
Washington State is such a pro-employee state
Exactly.
that, yeah, I'm totally in concurrence with Kirsten on this.
Great, thank you so much. And just so this group knows, we do have a template acknowledgement that we're putting up on that COVID resources page. So if you do want to download it and use it for your workers to utilize on set, that is an option for you. So kind of the flip side of that, as a worker, if you are presented with a liability waiver, is there anything you can do or say? I mean, you can say no, obviously, but do you have any advice for a situation like that?
Well, I mean, I think that as a worker, now that you've heard that it's probably not going to be enforceable, I guess it really, sometimes law isn't just law. Sometimes it's a risk analysis, whether you're
Right.
an employer or an employee. And as an employee, if your risk is, I can't pay my mortgage next month or pay my rent, and I really want this job, then, at some point you might sign a waiver just so you can get hired for a production if they have not listened, if the production company has not listened to either me or Kirsten. So that's how I would look at it.
Yeah, I mean, I would say if I was an employee, I will say as an attorney, I sign these type of waivers all the time going, it's whatever, I could bust through this thing if I needed to, right? And so I think from an employee standpoint, typically I don't say sign something just because it won't be unenforceable, but sort of to Jolene's point, I mean, people have families to feed, they have mortgages to pay. So if you were in that situation, I'd probably sign it knowing that if it came down to it, you could fight it and it very likely would not be enforceable.
Okay, thank you. So the employers, we know that they can create they need to be creating their safety plans and everything, but as an employee, is there anything that they can do to protect themselves from any liability while working, or either in their, if you're an independent contractor, is there something you should be including in your contract with your employer to protect yourself if for some reason the production gets shut down because of COVID or you get sick or around that, those terms?
You actually just brought something up that, again, I brought it up in sort of the first part, but remember, employee versus, it's very important at this juncture to realize whether you're an employee or whether you're an independent contractor, because you can put things in independent contractor agreements that you may not be able to do in employment agreements.
Yeah.
If you are an independent contractor, it means that you are responsible for your own business. So it's more of a business to business relationship than it is as an employee-employer relationship. So if I'm looking out for myself, I think that there's also got to be in this environment a certain level of flexibility that may or may not exist before COVID, because everybody's just trying to get moving again. And so if you have employees who are looking for, or contractors who are looking for any angle to try to secure whatever they can secure, if we were to go backwards, say in wherever our stages are, and a production had to be shut down or something happened, or somebody got sick and everybody followed the protocol and somebody still gets sick, you don't want to create a litigious environment. That's right. Something, as a lawyer, I know I'm saying don't create a litigious environment, but really we all have to be working together. So fostering that kind of environment, I think, has to go both ways, with the employer and the employees. And
I would agree with that entirely. And there's probably going to be questions that come up throughout this, that the theme is going to be flexible. I wanted to say one quick thing on the independent contractor employee thing really quick. I could do a whole hour seminar on the distinction between independent contractors and employees, but I think, Joleen has said it a couple of times. I will reemphasize, make sure, and this is to, business owners, make sure if you are engaging somebody that you are calling an independent contractor, that they are actually properly classified as such. Setting aside anything to do with COVID, this is a hotbed issue in employment law and labor law in general. And you don't want to mess it up, especially now. So
It has ripple effects through not just
absolutely,
but through how you run your business, through how you can get licenses, through your insurance. I mean, it's
all of it.
it's very important to understand the difference.
Yeah.
Great, thank you. I'm sure we'll have a lot of follow-up questions to that, but
Probably.
yeah, so I'll move on. And so I will save that till the end. So just getting into a little nitty gritty, do we know what like the employer's obligations are if you do have an employee who has to quarantine, a government imposed quarantine? And also sort of what you mentioned earlier, Kirsten, is, you know, if they choose to remove themselves because they don't feel safe, what is the employer's obligation to that employee?
Sure. So let's start with if someone tests positive and they come to you and say, hey, I've either tested positive or I know I've been exposed, right? And so I've been told by a healthcare provider to quarantine for the next 14 days. You know, your first duty to that employee is to say, okie doke. and you put them on quarantine. Your second duty really to that employee is, and I mentioned sort of in my preamble, this is where that overlapping, what leave rights does this employee have vis-a-vis paid leave? And so you need to look at what is available here. Is the employee quarantining just because they've been exposed? Did a healthcare provider tell them to quarantine? If so, they might qualify for that FFCRA leave. You know, so you need to make that option available to them if they haven't used it yet. If they've got available accrued and unused PTO or Washington State Sick Safe leave, they might qualify to use that. Depending on how your policy is set up. If they are actually sick with COVID-19, they may qualify, or they're caring for a family member, they may qualify for Washington paid family leave. So you need to navigate all of those leave laws, you know, not to pitch my services, I'm really not, but if you have an attorney, call them. Don't try to do this on your own, because if you mess it up, there can be liability there. Also with FFCRA leave, if you provide an employee with that paid leave, there is an employment tax credit you can take, so long as you have it well documented that the leave is actually for a qualified reason. So you want to get the documentation right so you can get that tax credit if it applies. So that's vis-a-vis that employee in that instance. If someone has come to you saying, hey, I've tested positive with COVID-19 or I've had a confirmed exposure, then you have a duty to the rest of your workforce to tell them, and here's where the tricky line is walked, because without the employee's permission, you shouldn't reveal their name, but to say, we have received information that you have worked closely with somebody who has either tested positive or has had a recent exposure. We encourage you to go get tested. You don't have to force them to, you don't have to force them to quarantine, but you at least have to let them know of the known case or the exposure so that they can choose whether or not to go get tested based on their personal circumstances. So that's in the instance of a confirmed case or exposure. If someone comes to you and they are just nervous about returning to work, let's not even guess at the reasons. They just are really, they would love to come back to work, but are super nervous about doing so. This is, again, where that flexibility comes into play. And also you need to think about, hey, you know, if somebody is this concerned about their personal safety, about catching COVID-19, maybe there is an underlying mental health condition that's happening. Even just the severe anxiety about catching the disease is probably sufficient, where you have to take into account Americans with Disabilities Act leave. That is separate and aside from anything having to do with Family Medical Leave Act. It is, and Washington state disability law also provides for leave as a reasonable accommodation of someone's disability. So again, your answer to that is totally understand. We don't want you to return to the work environment. If you are uncomfortable doing so, take the time you need. We will backfill your position in the meantime. Tell us when you are comfortable returning to work. That, if there's one key takeaway you take from this today, that is the one, because I firmly believe that that is what is required under the Americans with Disabilities Act, and to not do that leaves you exposed to a claim for disability discrimination and failure to accommodate a disability, because an employee can very easily get a healthcare provider to say that they were suffering from such severe anxiety about returning to work and catching COVID-19. And if you either force them to return to work or you deny them the ability to take the time off that they need until they're comfortable returning, even if that is not until there's a vaccine, again, you're exposing yourself to some legal liability.
Great, thank you so much.
Sure.
So a little bit on the flip side towards that end, if you are a worker and you've begun production and everything, but you have signed an NDA, but then you see really unsafe practices and you want to be able to report those unsafe practices, is there any way around that, or how should workers go about that?
I'll field this one too, because again, this really is more of a legal liability question. So an NDA, a confidentiality agreement, cannot prevent an employee from reporting or discussing the terms and conditions of employment for mutual benefit. This is called protected concerted activity. It is protected under the National Labor Relations Act for all employees, not just employees who are in a union. And we have a similar law under Washington state. Long story short, you can't contract somebody out of being a whistleblower,
Right.
whether that is to an outside agency or among the employees themselves. So I often get, before COVID-19, employers saying to me, like, employees are talking about their salaries amongst themselves at work and discussing what they earn and comparing salaries. And I'm like, yep. And they have a legal right to do so. And you can't stop them from doing that because they are engaging in protected concerted activity. So if you try to prevent that or shut that down in any way with your NDA, again, you are exposing yourself to a legal claim for, why did the term just fall out of my head? Love this at 4:37 in the afternoon. But suffice to say, there is a legal claim under the National Labor Relations Act for interference with rights under, I believe it's Title 7 of that act. Hot tip, if you have an NDA, it needs to have a disclaimer in it saying that this confidentiality agreement, the terms of this agreement, are not intended to and should not prevent an employee from engaging in protected concerted activity. If you happen to be sued under that law for engaging in wrongful workplace practices, your NDA without that disclaimer is Exhibit A in the case in favor of the employee, that your intent was to prevent them from bringing these types of claims to a government agency or discussing them among themselves.
On a practical level, I just wanted to also just talk about what is an NDA, because an NDA may not have the title non-disclosure agreement.
Yes.
So you might see this in lots of different forms. It could be in release forms. It could be in employment documents. It can show up in a lot of different places. So yeah, that's so cute.
His sister's at the vet. He's very concerned on her behalf. So
it could show up in just, again, so many different documents that, rather than trying to list all the types of documents that it could show up in, just make sure that whatever documents that you're signing as part of any sort of production package that you're working on, you're looking for those sorts of clauses. They could be embedded in bigger agreements. but that's the advice is the same. It's just don't look at NDA as
Right.
Great. Yeah.
Very true.
Thank you so much.
We're not dealing with lawyers. I mean, that's the thing to keep in mind. Like you can talk about different titles and different releases and different things. There's another overarching thing to keep in mind, that these can all look and feel very different in different types of productions. I work on so many different film production packages and agreements, and every different filmmaker will come to us with different forms that they've either used from other lawyers or they brought from other productions. And so for all of you that are in the industry, know that as lawyers, we see a million different iterations of this, and you should know that there are millions of different iterations.
Yep.
Great, thank you. Okay, I just have one more question and then we can open it up to the group. I'm not quite sure if you have the answer for this, but we know that we have a lot of production companies that come from outside the state into Washington to film. Do you know if they are required to follow our Washington state set safety guidelines, or do they have to follow from, like, say they're coming from LA, do they have to follow the guidelines from LA because that's where their company is based? Do you have any gauge on that?
I would say that they're going to follow the rules of where the location they're filming in.
Okay, great.
Yeah, I would say that as a general rule too. That being said, if you're going to compare, the two sets, I would say follow the one that provides the greatest safety to the employees, because then you're covered. I mean, I come across this a lot in my practice because I work with a lot of companies that have operations here and in California. And the question is always, which law do we follow? And I say, oh, California, because it provides the greatest protection. And if you are copacetic with California law, you are almost certainly copacetic with Washington, because they are just that much more employee friendly than we are. So, when all else fails, I agree with Joleen. Follow the rules of the location in which you are filming. But if you're just like, I don't know, follow the rules with the greatest protections.
Right.
Yeah.
Always. And that's for anything you do. So that
anything
kind of crosses across. The other thing to keep in mind with that is that if there are productions that are going cross-border, so you might be signing one production package, and maybe you're filming not just California, but you might be filming in a state that, let's call it a much less restrictive state than where we're at. I think that if I were to be able to give that production company advice, I'd do the same thing. If it's between Washington and Florida, go with Washington.
Yeah.
Yes. Thank you so much. Okay, that's all for me. I want to make sure we have enough time for everyone to say their questions, because I know we have quite a few folks who have those burning questions. So I'm just going to open it up to the lovely group. And yeah, does anyone have any questions off the bat? Anyone?
Awesome. You know it all. Yay.
Yeah,
I know, exactly.
You did.
It's like, don't be shy. We won't bite. It's all virtual. So
I should turn my video on. Sorry.
Oh, perfect. Thanks.
Thank you guys for doing this. This is amazing.
of course.
So one of the things that we're required to do is testing of cast and crew, and particularly with Screen Actors Guild, we're required to test 3 times a week. And it has come up as we started researching for testing that technically it's not legal, and this is, air quotes by doctors, to test people 3 times a week that are not sick. So it's interesting that our unions have required something of us. I'm going to stop there because I see you shaking your head.
It's just like a lot of things. It's like, you're trying to navigate. I mean, this is such a tough situation, and it's not just the film industry, it's all industry. It's like you're navigating state requirements, federal requirements, you're navigating guild requirements. And so I guess if it's not quote unquote legal, I don't know where you heard that, but if it's not legal from a perspective to test someone 3 times a week, but a guild is requiring it. I think that's when you start weighing the risks benefits of, okay, if it's not legal, what are the penalties of testing 3 times a week? And so figuring, that's kind of where you start having to navigate part of it. You can obviously have a lawyer help you look through all that, but there's always going to be some level of risk, cost benefit risk analysis in anything you're doing.
It sounds like it's more of an ethical, when they do the air quotes, it's like, well, you're ethically asking to be tested when you don't.
The guilds have so much control over, the ability of people to function in film and production industries. Sometimes the guild penalties are more scary than if you test someone 1 too many times.
Yeah. I mean, I will say, so if you're hearing this from doctors saying it's not legal to test people when they're not actually sick, that is probably coming from their understanding of what the Americans with Disabilities Act requires. And I would say in typical world, they are very likely correct. In our normal environment, you cannot just test employees, let alone multiple times a week, assuming or guessing that they might have a disability or some illness that prevents them from coming into work. I will tell you that the EEOC has specifically stated this is a global pandemic. The rules are different for pandemic response. And the EEOC, and hot tip, that's the agency tasked with enforcing the Americans with Disabilities Act. In Washington State, it's the Human Rights Commission. They have acknowledged sort of this balance between, the employer under OSHA having to provide a safe and healthful work environment, and this tension with the ADA of testing people. Long story short, I think these doctors are bunk. They are thinking about pre-COVID-19 ADA requirements. It is absolutely legal for employers to now implement workplace testing to ensure that their employees do not have COVID-19. That is allowed under the ADA. It's been, I'll use air quotes now, approved by the EEOC, right? But you are not, to the very best of my knowledge, running afoul of any law by requiring testings, whether it's under your guild, a collective bargaining agreement, Governor Inslee's orders, anything like that, because of the pandemic nature of this disease.
The reverse, though, is something that I have seen, believe it or not, even though we're in Washington State, where there are people that don't want to be tested and they feel like that's an invasion of their privacy, and maybe they don't want to know, or they don't want to,
Yeah.
I mean, you're seeing people walking around without masks too, so that's kind of a whole other ball of wax that you didn't ask about. But, what if somebody doesn't or refuses to take the test? Can you?
You can refuse to allow them onto the work site.
Right. And that's what I was, exactly.
Yep. Yeah. I'm surprised nobody asked that one. So I'm glad we asked it for you. but that, again,
because we all live here, most of us are probably wearing our masks at home. We have to do it.
Yeah. But that's another one that's a pretty darn clear line in the sand. Is this is now workplace policy. If you are going to get onto your work site, whether that be a production site, an office, wherever, and the employer, whatever is requiring you to, have the temperature testing and to do, I have clients who are daily checking the temperatures of their employees before they're even allowed in an office, on a construction site, in wherever, and they have to answer the questions. Do you have you lost sense of taste? All of those questions.
Oh, yeah.
every single day. And if an employee refuses to do it, you can deny them access to the work site. And it's
probably better, by the way, than a waiver.
Indeed.
The questionnaire.
Questionnaire. Follow policy And
Yeah.
that gives you a lot better of a checklist than just signing some waiver.
Indeed.
Mhm. Beautiful. Thank you. That was a great answer. I feel no guilt now. about
Good. You
testing.
shouldn't.
About
You should
testing.
not.
So we have a question. So is there a right way and a wrong way to ask someone who's not following protocols to leave a set?
Yeah, someone who's already been hired, already on the set.
They're already in the workplace. They take off their mask and they just have to take it off.
I mean, if it, Kirsten, you can jump in, but I always look at it as I would do for any employee that's doing something wrong. I would give them a warning and ask them to follow protocol. And if not, whether you write them up or whether you expel them at that point, I think that you have every right to require that they are not endangering the health of everybody else around them.
So give them a warning, say these are the protocols, you've agreed to them, you're not following the protocols, either put your mask on or leave.
Like I said, I think that it's good to have the protocols, whatever your protocols are,
Yeah.
and before they are even
Yeah, sure.
brought on board, this is what they are. And then if they don't follow it, ask them to do it. If they are continuously, it's just like anything else, if they're continuously being insubordinate, it's at some point decide when that's the rest of your team.
Yeah, and I'll just dovetail on that and just bring up one thing that an employee might respond to. And this is what people have been saying, just out in the public world about not wearing masks is, well, I have insert medical condition here where I can't wear the mask. Whether it be, again, anxiety, some condition where they feel like they can't wear the mask for their medical condition. And so they might respond saying, well, you have to allow me to take it off or not wear it at work because I'm disabled and this is a reasonable accommodation. And the answer to that, I will tell you, is no. So like with any disability and any accommodation analysis, the employee is entitled to an accommodation, not necessarily the one that they are demanding. So if the employee cannot wear a mask at work for whatever reason, the answer is either, well, let's find you a type of mask that works. So maybe the answer is, a clear face shield as opposed to a mask, correct? Or if that's not available, then the reasonable accommodation that's provided for them is a leave of absence, unpaid by you, unless there is some other qualifying reason that gives them paid leave, i.e. they have accrued and unused PTO. Leave is considered a reasonable accommodation when there is no other accommodation that allows them to perform the essential functions of the job. And I will argue on any employer's behalf that in light of the requirements put into place by the government and all of the guidelines in place, that in order to perform the essential functions and create a safe and healthful work environment, that includes at this time wearing PPE, whatever that means for your industry. So if an employee can't do it, they either go home or you find the type of PPE that would work for that employee if they have a disability.
Remember that we're in Washington, so we actually do have a lot of support at a governmental level, not just the state, but city, county level to back that up. If you go over to Idaho to film part of what you're filming, all of what we're saying on the employment side is true, but you may not have the same backup if you are not able to reasonably accommodate them. I mean, you will under the federal act, but be aware of where you are in your environment.
Thank you very much.
Rebecca.
I have a question. Again, thank you so much. This has been amazing. As an employee or as an employer, who has the right to know your test results?
Well, so the employer has the right, and I would say within that bubble, anybody on a truly a need to know basis. So I would say HR and maybe your COVID-19, site manager or whatever. Other than that, really, it should be treated like any other medical information of an employee, and it should be confidential. I've
payroll and lawyers too probably would end up knowing.
Yeah, I mean,
functional standpoints.
Correct. Yeah. I mean, yeah, if you're the employer and you tell your attorney, right, that's going to be all privilege and everything. But as far as other employees, again, barring permission from the employee who's been infected or just, temperature results or whatever, those should be kept confidential. Nobody has the right to know. And if somebody, if somebody is sent home from work because their temperature, was too high that day for to be allowed onto the work site, or they go home because they've told you they've tested positive for COVID-19. I mean, really the message to employees is, again, just generally, there has been potential exposure in the work site. We encourage you to go get tested, and you don't reveal the name. Now, if employees are smart enough to piece it together, that's on them. That happens again, in the workplace in general.
You might tell everybody themselves too.
I've been surprised at how candid. Maybe it's a good thing, but people have been like, yeah, I've been exposed, super sorry. I'm headed home. But I would say if you're an employer and you're doing the testing, you're taking the temperatures, any medical information should be kept in a separate file from the employee's personnel file. This is not personnel file information. If you still keep, hard paper files, I'm a huge fan of color coding, frankly. So, a red folder, something so that if you saw this out and there's a red folder sitting on a desk somewhere, holy mackerel, that's medical information. What is that doing out? That should be under lock and key, because it really should be. And
I was gonna say that too, because if you're putting the results in some sort of database or computer, think of all data. If there's data relating to medical conditions or confidential information, you want to really, really protect that from anyone being able to get it. Password protect if it's electronic data. Yeah. I love the red folder idea.
Yeah.
Okay, I think we have time for one or two more questions if anyone has one.
One quick thing.
Sure.
On the governor's protocol, the ones that's been approved, it says a cloth mask specifically. So does that mean you have to have a cloth mask? You can't use like the kind you get at the doctors because a cloth mask is not disposable. So how is an employer supposed to provide cloth masks for all their employees?
The answer to that.
Yeah, I mean, so here I'm putting my lawyer hat on, right? And this is where you can really get in the high weeds when you've got a law degree, right? What is cloth?
Yeah. There is an actual page, and we link to it in our protocols that explains exactly what is yay and nay. And I can find that for us, but it is linked on our website.
We read it. And it says cloth.
Yeah.
Everything, cloth.
It does not say, what it does say is you're not allowed to wear an N95, but you have to wear a cloth. So is cloth the blue paper, the yellow paper? Is it something other than an N95 that's made of, a paper product?
Because a cloth has to be washed. It can be washed.
It has to be washed every day.
Yeah, but how does
the employer do that?
Yeah, so here's what I would say, and again, this is where real life intersects with the law, right? I would say, without reading this specific guidance, and now I'm going to go back and read it and try to figure out if I can decipher exactly what they mean by cloth, and if it excludes a medical mask like you guys are describing. My best guess is well, here's what I would say from a practical perspective. If you're providing your employees with a fabric medical mask, right, that is disposable to wear at the workplace, that's the PPE that you can provide. I think this is where we do risk benefit analysis, right? I think the risk of somebody coming to your workplace and saying that is not okay is very, very low. And if they do, you have a reasonable defense of, this is, from our interpretation, this was cloth, mea culpa. What do we do better going forward? I honestly don't think, and the governor has said this before with other requirements, I honestly think if you are trying and you are acting in good faith to follow the guidance, you are not going to get punished for that. And as far as, exposing yourself to liability from employees, I think, again, really, and I just thought of one question that was in the list that didn't get asked that I really want to make sure we address, which is whether or not somebody getting COVID-19 at work is covered by workers' comp. Hot tip, it is not, as a general rule, unless you're a healthcare provider or first responder, which means the potential exposure is to the employer for negligence. I don't think, and I have no crystal balls, this is my best guess based on years of practice and whatnot, is that if you are providing employees with reasonable PPE, the medical masks, you're giving them a new one every day, or if they're like, oh, I went to the bathroom and dropped it on the floor, and you give them a new one, right? I think they're going to have a very tough time, one, ever proving that they caught COVID-19 at work, but let's set that aside. If they could prove that you were negligent in your practices in providing that level of PPE. So, that's the best advice I can give. I don't see on a practical level how employers can provide, the type of cloth masks that my mother-in-law so generously sewed for my husband and I, right? It's just not practical. So if you are providing a medical, a medical type of paper mask, I will argue on your behalf that is cloth, that you are
Right, the governor's office and request clarification too. I mean, there's a lot of people in the industry.
Yeah.
If that's something that you feel, I mean, it seems like a reasonably easy clarification to just say, is this cloth, or do you really mean cloth?
Thank you, Joleen and Kirsten, so much for joining us.
No
if folks want to reach out to you, how can they find you? What's the best way to get connected with you?
You can find me at hmlglaw.com. I also have a podcast called The Lawyer Who Rocks. I see one of my guests down there. Hi, Kate. So those are two places you can find me. I'm all over social media.
Yep. And I'm at Karen Cross, CARNCROSS.com. My email is kdaniels@karencross.com. My number is 206-254-4454.
Thank you, ladies, again so much for joining us today. And we will see everyone very soon. We have our webinar next Friday at 11 a.m., kind of explaining more Q&A about what does it mean that we're greenlit to go film. So we're very excited about that. So
we're excited for you.
Hey, thank you. We all worked really hard on this, so we're all very
I bet.
Okay, so thank you guys so much and have a great rest of your evening.
Thanks, everybody.
Thank you.